Hello and welcome back to Introduction to U.S. Law. Today we're going to start talking about family law. In the United States, family law is mostly state law. You might remember from our discussion of the Constitution that the Constitution limits what the federal government can control, and the federal government does not get to enforce the police powers. That's up to the state. And the police powers include the laws that relate to the formation and running of a family. So it's mostly state law and it's mostly statutory. It's not the common law, it's mostly statutory law. Now federal law is still involved a little bit. There are constitutional issues. Someone's individual rights still have to be protected. So state law cannot interfere with any of your constitutionally protected rights. And there are some federal benefits for aid to families and issues of child support that transcend any one state. So mostly state law, but we see a little bit of federal involvement as well. A lot of family law has to deal with marriage, a very important factor in the United States life apparently, and probably around the world. So there's something called a ceremonial marriage. That is where you solemnify your marriage, you intend to get married, you go to get a license to get married, and you are legally married, and every state in the Union will accept that as a valid marriage. The first thing we have to do to validly marry someone is to meet the age requirements. It's usually 18 years old. When you're 18 years old in any state, you can choose to marry whoever you want. Now, it's different from state to state. You can be as young as 14 years old in Texas if you have parental consent and judicial consent as well. In Mississippi, there's actually no minimum age as long as you have parental consent and a judge consents to it as well. So how young is the youngest? I don't know, but there is no minimum set for Mississippi. You also have to show that you're mentally competent. And that's kind of one of the issues for allowing children to decide. That's why we need to get parental and judicial approval for very young people, because young people under the age of 18 aren't considered mentally competent to enter into a contract. And marriage is just that. Marriage is a contract, a very specific contract that's enforced by the state. You also have to enter into marriage of your own free will. You have to really consent to it. You may see some movies, some cartoons where somebody's getting married at the end of a gun. They call them shotgun weddings. You may know why or why not they're getting married, but the idea is it's not a valid marriage if it's not of someone's own free will or consent. And every state I will say, requires a license. So you have to get that license. And then one more thing, some solemnization of the marriage. You can do this a number of ways. You can go before a judge who pronounces you married, or you can do this in front of a member of the clergy in most every jurisdiction as well. There's a number of ways you can do this, but you must have that solemnization. There's also something called common law marriage, not like the ceremonial marriage, and only about 1/4 of the states recognize common law marriage. It used to be almost everyone, but because we're making family law statutory, a lot of states have gotten rid of this. And if they are legal in one state, full faith and credit in the other states holds that other states must recognize them as well. So they're a little different from state to state, but they all have these basic requirements. If you're claiming common law marriage, you're claiming that the two people have held themselves out to the public as being married, that they've lived together as a married couple, and that they've consummated the marriage. And for those of you unfamiliar with the term, they've had sex. When those requirements have been met, in many states, they've met the requirements for common law marriage. You'll note there's no particular amount of time required in most states. So in some states, if you went to a motel with someone and you registered as husband and wife to avoid any issues, you've now held yourself out to the public as husband and wife. And it doesn't say how long, so you're there at the hotel overnight, you're living together as man and wife, and if you have sex and consummate the marriage, you could be legally married in many states. This comes up in issues of an inheritance. So you don't think you're married, you may not have even seen this person for a long time, But if you drop dead and the other person claims that you were married, this could change all of the inheritance issues, even if you have a will. Because remember, from our discussion about property, a spouse is always going to get something statutorily, even if your will doesn't provide for it. So this can play havoc with issues of inheritance down the road. Also, with issues of pension rights. If you are earning money while you are legally married to someone, they have a right to your pension as well. You have a greater right, of course, and Social Security provides benefits for people who are married to Social Security wage earners. So there's a lot of issues that come up when you are involved in a common law marriage, especially if you don't know you are. Some people, this is the way they choose to get married. That's different, and then none of this will be a big surprise. Other issues with marriage, common law especially, is you have certain property rights in marriage. Now, in the old days, women weren't treated very well in the eyes of the law. Some would argue still some issues, but single women had similar property rights to men concerning property, but married women not so much. So a married woman's legal existence merged with her husband once they got married. And so a married woman could no longer legally enter into contracts. What? Yes. Her property upon marriage became the property of her husband. Now, later on, of course, we realized that this was really unfair and unjust, and that was the common law. And as I told you before, most family law now is statutory. We have the Married Women's Property Acts, which tried to fix this inequity in the rights of women versus men. Also, property rights in divorce. Under the common law, we're looking at separate property. Upon divorce, an equitable distribution of the property for everything that was acquired during the marriage. They look at the contributions of both parties, and that's the common law approach. We're going to look at everything they brought to it, whatever they got during the marriage. A community property approach says, this is a minority of states, and it's similar to the civil law in Europe, by the way. All property that is acquired during the marriage is community property. Prior to marriage property, or any inheritances and gifts you get because you're inheriting them from one of your family members, are your separate property. They remain separate from the community property estate. It seems pretty simple, but when we look at things like retirement benefits, property acquired prior to the marriage but paid for during marriage can really cause problems. If you came to the marriage with another piece of real property, but out of the marriage assets you paid for that property, then part of that has been acquired during the marriage. So it sounds pretty neat and clean, but it's actually quite messy, property and divorce. And that's why divorces can be very expensive and can be tied up in litigation for a long time. Now, if you want to try to avoid this type of litigation in case your marriage doesn't work out, you can engage in premarital agreements. You can make a contract before you get married for the division of property if anything goes wrong. Traditionally, this was for when a spouse died, but now it's very popular, especially with couples of disparate wealth. So if the wife is bringing, or sorry, one partner I should say, because marriage is not only between man and woman, if one partner is very, very wealthy, the other is not, sometimes just to make sure that they weren't being married just so they could make a lot of money, people would ask them to sign a premarital agreement that recognizes that their money is separate, that I am the rich person, and if we separate, this is exactly how much you will get. It certainly is practical, certainly not very romantic, but most jurisdictions do recognize these premarital agreements. Not every jurisdiction does. Some of them will still require you to follow the regular rules of divorce and separation of property. Some jurisdictions will look to make sure they're fair to both parties. And if both parties had independent counsel, if both parties had a lawyer making them, those are considered more likely to be valid than ones that were just imposed upon one party, like say by the wealthy party who had a lawyer draw up the agreement. And then finally, we need to discuss the dissolution of marriage, a divorce. And traditionally, it was a civil lawsuit in equity. We're asking the court to do something. Traditionally, you had to prove fault. And the typical means of proving fault were that someone was a drunkard, or someone was an adulterer, or there were physical or mental cruelty in the marriage, or abandonment, or even insanity were grounds for divorce. No-fault divorce was not introduced until the 1960s, and it's available in virtually every jurisdiction now. And in no-fault divorce, we're saying that the marriage is irreconcilably broken. It's irretrievably broken. It cannot be fixed. There's no reason for it to go on. In general, if one wants it, they just have to show either irreconcilable differences or perhaps incurable sanity is also a way of proving this. But there are no longer any states requiring you to prove fault like adultery, adulterous behavior, or cruelty. There are a lot of procedural issues in divorce. There's an issue of domicile. Domicile is a little bit different than where you live, but that's a major part of it. Domicile is very specific. It talks about where you live and intend to remain indefinitely. So it's kind of difficult to establish sometimes what your domicile is. And these divorce proceedings sometimes bring a lot of acrimony into the court. And so a modern approach is to make an effort to mediate or arbitrate the terms of a divorce before it gets to court, because these can be really nasty affairs when things go south. There's also a way to end a marriage that's a little different called an annulment, and that is kind of a legal fiction that says we're going to say this marriage never occurred. And there's various reasons for doing this, but they're limited. It's usually only for a very short time. Perhaps two people were drunk and they were in Las Vegas and they saw Elvis and decided that Elvis should marry them. The next day, if they haven't consummated the marriage, it's very easy probably to get that annulment because neither one of them had the real intent to be married. They were just very drunk and didn't really have the mental state required. But annulments are not very easy. But the idea is the law would declare you've never been married. It's also something just short of divorce called a legal separation, where you are not divorced. They say you're divorced from bed and board. So you no longer live together. You don't share the household together. You don't eat and sleep together. That is a legal separation. Sometimes the courts will allow that to give you time to perhaps fix things up, or perhaps for a limited amount of time until the children have grown. But that's a legal separation. You're still technically married. In divorce, one thing that can be given to one of the partners in a divorce is alimony, and it's support for that spouse, money support. It can be a lump sum. If there's a great deal of money in the marriage, they can say one of the partners, one of the former spouses, is going to get X amount of dollars. Or they can say someone's going to get X amount of dollars per month. If that person dies or remarries, that ends the alimony. But otherwise, it continues on. And to decide how much it is, the court will look at a number of different factors, including the financial resources of both partners, what the standard of living was within the relationship, any kind of child support that may be needed or already being given, the time necessary for the spouse who's getting alimony perhaps to retrain into a new profession so that they can support themselves. They're going to look at the duration of marriage, what their standard of living looks like, and the age of the spouse seeking alimony. And they'll look at the financial status of both parties. If they're both independently wealthy, alimony is probably not indicated. Besides alimony, of course, we're going to have to divide up the property. And the goal is to divide it up equitably or fairly. We want to make sure everybody gets what they should. But that's tough. Factors we're going to look at here, again, are going to be duration of the marriage, whether there were prior marriages, what you brought in from that prior marriage. The courts, not every court, but most courts will look at any prenuptial agreements. Did you decide on property settlement before you even got married? They'll look at the health, the age, the occupation, the earning power, and the employabilities of the parties. They'll also look at any liabilities each party has. Maybe one party has a lot of credit card debt or owes a lot of money on a particular piece of property, and any alimony that's going to be given. So the court must try to be fair, because this property settlement will become part of the divorce decree, and so it has to be judicially enforceable. So we want to make a fair property settlement. One issue that came up a lot was where one spouse supported the other spouse when they went through education, like let's say a spouse put his or her spouse through medical school. And that's a long time. We're talking about 4 years and 4 years plus residency, and that's at least 11 or 12 years to become a practicing physician. And at that point, after supporting that person for 12 years, the physician then turns around and says, I'm divorcing you. In the property settlement, the person who did all the support may actually get alimony that we talked about for retraining. Now it's their turn perhaps to get an education, or perhaps just a greater amount of the property settlement because of the future earning potential of one of the partners. What kind of property is subject to division after a couple separates? Almost anything of value, and that includes human capital. So if someone has a professional degree, like in the little story I just told you about the physician, that's going to be taken into account, their earning potential going forward, and retirement accounts. It can be in a pension form, could be a 401k or another account that has money in it. All of that is subject to division. And as a matter of fact, under federal law, the spouse has a right to a portion of the pension that was acquired during the marriage. Another big issue in family law is custody of children. Legal custody under the common law was simple. It was traditionally the mother got the children, unless there was something really wrong with mom. Custody of children includes more than physical custody. It includes the right to make all decisions pertaining to the child's upbringing, their education, their health care, religion, their growth and development. And it usually does include that physical custody of the child. So one parent can be given full custody. They may have shared custody. Perhaps one parent has the child during the weekdays, one on the weekends, or every other weekend. There's myriad ways that we can share custody. But for the parent who does not have custody, visitation is almost always awarded. It can be overcome in extraordinary circumstances, like perhaps a parent is abusive. They may be kept away from the child, but otherwise parents get visitation. Visitation can also be given to caregivers. So perhaps someone who was not the actual parent of a child, but they were the caregiver within a marriage, or even not even a married partner, and they're deemed to be psychological parents, people who are so influential in bringing up that child that they're considered like a parent. This could be a grandparent that stepped into the role for an absent father, something like that. They may be able to get visitation rights. It's not as common, but courts are more willing to look at it. And the standard we use when we're looking at whether or not there should be a custody issue or a visitation issue is the best interest of the child. We're going to look to see what would be best for the child, not what the parents want, what the parents' interests are. It's what's in the best interest of the child. They'll look at the lifestyles of the parents. And so when we're trying to decide who should have custody or how much limitation there should be on visitation, we will look to see if the visitation, if the lifestyle of the parents should be a determining factor in awarding custody or visitation. In the old days, not too long ago, I might add, if a parent was lesbian, gay, bisexual, or transgender, that often meant they were not going to get custody, and sometimes absolutely no visitation as well. All of these rules are changing now. That lesbians, gays, everybody has the right, every consenting adult has the right to marriage. These are issues, LGBT issues, are fading, but still prevalent in many states, particularly in the South. And the final thing we look at are the preferences of a child who's old enough to understand the ramifications of their decision. So just to wrap up the issues of visitation rights, remember the visitation is for the non-custodial parent for the most part, or non-parents. The key thing we're looking at is the best interest of the child, so the stability for the child is the most important thing that the court's going to consider. People involved with these situations where the child is going from home to home have to be flexible, and reasonable is always going to be the goal, and everybody should be coming from a reasonable place. This does not always happen. That's why the courts have to intercede. Especially important when one parent is leaving the state. If the custodial parent wants to leave the state, it is usually allowable that one parent can leave the state, but this definitely impedes upon the other party's visitation of the children because they're leaving the jurisdiction. Sometimes it's not allowable, but generally it is. Now, I did mention a little bit joint custody, and that just means the child is living part-time with each parent. It's very popular these days for one party to get every other weekend, and that's it. And most states permit joint custody. It's still a little bit controversial because, remember, custody is all about not just physical possession of the children, but decisions of religion and upbringing and education and health. And so sometimes the court will allow the person with the greater custody, the greater amount of custody, to make those decisions. Sometimes they're supposed to do it jointly. And that's often difficult between people who may have had an acrimonious ending to their marriage. Another issue is interstate enforcement. The court may direct that they have to both remain within the state, but there's not much they can do when people do move from state to state. And we'll talk a little bit more about this in our next week's module when we talk about choice of law, but federal law limits forum shopping. You could, knowing that your state is going to enforce rules against you in a way that's going to disfavor you over your ex, like in the case of the lesbian mother that I talked about earlier. You can't just run to another state and get a more open-minded state to rule on this. You can't do forum shopping like that. You have to go to the state that has the control over the case. The issue of child support. Now, traditionally in the common law, the father was responsible for paying child support. Nowadays, it's both parties. In the old days, we also had paternity issues. And in the old common law, it was presumed that the husband of a child born of a married couple was the father. And we had limited ability to determine if that was in fact true. But nowadays, we have all sorts of ability to determine whether or not someone is truly the father, but we still have those presumptions. And so we're not going to look at that unless it becomes an issue. But in supporting a child today, both parents have that duty, and they must provide for that child until the child reaches the age 18. Unless they're incapacitated, mentally or physically, you may have a duty in some states to take care of that child for a lifetime. Other states don't require that, but at least until 18. There's also an issue of emancipation, and it's an old term that we also used when we said slaves were no longer owned. It's an interesting way of looking at our children, but children can ask a court to be emancipated at an age younger than 18. And famous cases of this would be child celebrities, like child actors who make a lot of money and their parents are squandering their fortune. They could ask to be emancipated by a judge and actually be considered adults at the age of 16. The parents no longer have control over them. And there are, of course, issues about the amounts of support as well. Of course, each parent is going to try to argue in their own best interest what the appropriate amount of support is. Adding to this mix for people who don't have a lot of money, we have welfare programs called Aid to Dependent Children and Their Families. The state, through a federal government program, does indeed temporarily help people with money or food stamps, which are vouchers to help you buy food. And the focus on these welfare programs is supposed to be on redirecting you to help you to be able to succeed without help from the state. And Sometimes they also offer training. Although some strange quirks in the law for a long time said that if you were going through an education program, you could no longer collect like unemployment. So people would either have to stop their education and just take a very bad job, or suffer with no income or no any kind of support while they got their education. So we've tried to make these a little bit more sensible, but they still have a lot of problems. So enforcing these child support orders is a state issue. And a lot of people are surprised to find this out the hard way, that a state can hold a non-payer in contempt of court. And that could mean a lot of things. That could mean their wages will be garnished. That means the court will reach into the employee's paycheck. So the paycheck will come directly to the court and not to the person. Now, they won't garnish the entire wage, but they can take a certain amount of the non-payers' wages each week to pay for their child support. And if a parent does flee the state, there's going to be a reciprocal law requiring the new state to enforce the child custody issues. It's not the same as full faith and credit, but every state shares these burdens and support for other states because every state has issues of child support. So states are willing to help each other out. There are also some federal non-support laws, much beyond the scope of our discussion here today. So within family law, it's getting less and less of a contentious issue, but we had to deal with non-traditional families. So we have heterosexual unmarried couples, and they can choose not to get married and to raise children and to do all the things that a married couple would do, but they don't get all of the rights and all the responsibilities that are required of and given to married couples. And while that may be their decision, there are a lot of federal benefits that come from being married, a lot of state benefits. There's a few drawbacks. Some people feel that they do more poorly with their tax liability being married than they were when they were single. But it's a choice that people can make. And so traditionally these people were really looked at rather poorly, and the children of unmarried couples were actually called bastards. It meant that they came from a mother who was not married. The term bastardy has been gone from every state's law for quite some time now. But heterosexual unmarried couples still face some challenges, although most courts treat them equitably like those people who are married, but not with all the same rights. Gay couples used to not be able to get married, and that recently changed in the United States with the Obergefell case. Now consenting adults who are not otherwise married can get married just like everybody else. Before, gay couples were limited to civil unions, which they can still do. Unmarried people can still get civil unions in some states. It gives you a lot of the benefits of marriage, but not all of them, including intestacy issues and including pension issues. So it's important to understand what you're getting into. The Defense of Marriage Act was specifically overruled by the Obergefell case that said no state would be forced to give full faith and credit to a gay marriage, among other things. And there were issues, as I mentioned before, for that lesbian couple of being a gay person who was parenting a child. Now the rules are somewhat softening, and gay and lesbian couples are treated very much similarly to heterosexual couples in the eyes of the law, if not in the eyes of people who enforce the laws. I'll leave it at that. So I want to talk a little bit about adoption. Adoption can be voluntary or it can be involuntary. Babies versus children. Babies, of course, don't have much say in what's happening to them, but people can be adopted for a number of reasons. People can give up their children who they don't believe they can take care of. But the state can also take a child's, a parent's parental rights away from someone who is abusing their children or neglecting their children. And so you can lose your parental rights involuntarily or voluntary. With babies, the children, of course, the baby has no say in the matter. The baby is unaware of what's happening to a degree that they can participate. And children, after a certain age, can participate in the decision for adoptions. Foreign adoptions were very popular for a long time, especially from Russia and China. Russia has put a stop to American adoption of Russian children, and other countries have slowed it down as well. China is also putting the brakes on it. And there's an issue between agency and private adoptions, and states have their own requirements to adopt. Another popular way of adoption is to adopt foster children. Foster children are children who are wards of the state, who are being kept by the state because their parents are unable to do it, either voluntarily or don't have the wherewithal to take care of their children, and they're abusing or neglecting them. Sometimes these children will end up in foster homes, and eventually, if the parents' rights are terminated, these children can be adopted as well. So while we're talking about family law, one of my favorite topics in family law is the issue of artificial reproductive technology. And this is one place where the law has had difficulty keeping up with technological innovations. So in the old days, if a woman gave birth to a baby, it was very clear whose baby that was. It was the mother of the baby she gave birth to. But technology has changed. We have artificial insemination, where we can go ahead and we can have a married couple or just single woman or whatever. We can have a woman inseminated by a man she's never met, by someone she doesn't even know who it is and has no ability to find out. You can buy donor sperm and artificially inseminate a woman. It can be by an agreement, a contract. And now we can take it even a step further. We can have in vitro fertilization. In vitro just means in glass. So we can take a woman's egg, seminate it inside that little petri dish, and then implant it into yet a third woman. And the law has not kept up with this technology. Remember, the definition, the legal definition of a mother was the woman who gave birth to a child. But what if one woman donated the egg and another woman gestated the baby? Who would be the legal mother? If the law has not changed, it would be the woman who gave birth, but it wouldn't be her genetic offspring. So let's take a look at this little chart here. And here we have a situation, and it's a very famous case out of California. And we have the intended parents here. We have a husband and a wife, and we have a surrogate. And so they actually added a fourth person to the mix. The husband in this particular case was incapable of creating the sperm required to have a child, so they got a donor for the sperm. And the mother did not want to go through the surgery required to harvest an egg, so they got a donor for the egg as well. So we have two donors, a surrogate that is going to gestate the baby, a husband and a wife. So the real interesting thing in this case is, as they were about 3 months into the pregnancy of the gestational surrogate, the husband and wife decided to get a divorce. And the issue was, who were the parents of the baby? Is it the genetic predisposition, genetic donor? Is it the woman whose egg it was? That would be her baby. Is it the gentleman who donated the sperm, who contracted for no parental rights whatsoever? Is it the husband and wife who have absolutely no genetic connection and apparently no love for this child? Who is it? And the court had to look, and the court would say, well, in the traditional common law, it would say the woman who gave birth is the mother, but that would lead to a very unfair result. This woman had actually given birth to children before for couples who were unable to have babies, and it was a great thing she did, and she enjoyed doing it. She enjoyed helping people out. And so it would be unfair to punish her with a baby she didn't want and have to be responsible for 18 years. Similarly, the donors of the genetic material agreed in contract that they would not be in any way asserting their parental rights for the child, so the court found they shouldn't have them asserted against them as well. And they came up with a new test called the intended parents of a child born of artificial reproductive technology. They said the people who put all of this in motion, who were always supposed to be the intended parents and would demand to be the legal parents if any one of the people involved decided to assert control or parentage of the child, should be held to that same standard, and found the divorced couple were the actual mother and father of the child for legal purposes. But this has come a long way from the common law. Under the common law I mentioned earlier in paternity, that a father was deemed to be the father of a child born of a marriage. And it's a presumption that could be overcome. The father suspected something, like perhaps the baby born bore no resemblance whatsoever to the father. They could disprove the paternity with a blood test, but it was presumed to be the child of that father. Well, now we have to apply the same rules for maternity as well in states that haven't changed their laws to have something like California does, the intended parents. In some states, you can't really have a surrogacy agreement unless you really trust that person, because the law would say the woman who gives birth is still the mother and the genetic contributor is still the father. Enough of childhood and lovely things and babies. Let's talk a little bit about something a little bit darker, and that's abuse. There's something called spouse abuse. And we used to say, wife abuse, but both husbands and wives can be battered by their partners. And of course, we sometimes have two husbands or two wives, so it's spousal abuse. And in those cases there, the law is a state law that dictates what will happen in the event of spouse abuse. There's also child abuse and neglect. And as I mentioned before, the state can step in and remove children from the house to protect the children, whatever is in the best interest of the child. If it's severe and they don't think it can be fixed, the state can actually terminate the parental rights and make that baby a ward of the state, or make that child a ward of the state and eligible for adoption. That's going to do it for family law. All right. We're also going to talk today about administrative law. Now, you might remember from my discussion in week 1, if you can even remember back that far, about administrative agencies. Remember, they're not provided for in the Constitution, and the federal government's only supposed to have the powers given to it by the Constitution. Well, way back, Congress decided to have the Interstate Commerce Commission. So Congress has the right to create bodies to help it do its job. And the very first administrative agency was the Interstate Commerce Commission in 1887. And as I mentioned before, many more came about during the Depression of 1928, 1930. We saw all sorts of agencies that were created to help our country get out of its depression. Now remember, the Congress forms the agencies, and they are the ones that pass a legislative act that enables these agencies to be formed and allows the agencies to make their own regulations. Right? And their regulations, they're called rules, but they have the force of any statutory law. They're mandatory, just as if they were statutory law. And remember, there are 10 times the number of administrative regulations as there are statutes. Now, the whole idea of this is, of course, that some things are very complicated. Like aviation is very complicated. Medicine is very complicated. And so we don't really want the Congress, the House of Representatives, and the senators, we don't want them writing complicated rules on practicing medicine or running hospitals, because they don't know much about that. There may be a few physicians in the Congress, but for the most part, that's outside their area of expertise. So they write a statute that enables an agency to promulgate these rules that will do these things. And so the agencies are run by experts in the field. Like we have the Department of Health and Human Services, and usually run by a physician, and people in the field know something about the field that they're regulating. And that's the idea of the administrative agencies. They enforce their rules. They have their own tribunals, the administrative tribunals, that are run by administrative law judges. So you can be brought into an administrative law tribunal for violating these rules. And so again, specialized agencies still has congressional oversight. The General Accounting Office also provides some sort of oversight as well. And I'm just going to pop this right back up. This is our little graphic concerning the checks and balances between the 3 branches of government. And remember, administrative agencies are provided for by the legislation, but they're run as part of the executive branch of the government. So we have a check and balance here. The legislation provides the money, and so can stop the administrative agencies from doing something that is overreaching. And the judiciary can also make sure that their rules and regulations are within constitutional limits. So the president appoints the high-level officials, the Senate confirms, and again, that Congress controls their statutory authority and their budget allocations. So you might look at administrative agencies as kind of a hybrid. They have quasi-legislative powers, right? They make rules that are binding. They're not statutes, but they are binding rules. And they also have executive powers, right? They investigate and prosecute violators of those rules. So they do a little bit of both. But wait, there's more. They actually also have judicial powers because they have their own administrative tribunals. So they really are a hybrid. And they fit really well within our system of checks and balances. So their rulemaking procedure is different than that of Congress. They have to follow the Administrative Procedure Act, the APA. And this requires them to give a notice period and a notice and comment period during their rulemaking. So an administrative agency that wants to write rules, let's say about the regulation of a hospital, will put out their proposed regulations, and they distribute them to the people most likely to be affected by them, and they're published in something called the Federal Register. And anybody can look at the Federal Register anytime. And people can make notes and comments about how this will affect their hospital system, their life, and they accept these comments. Now, they're not binding on the agency, but the agencies must consider all of these objections and comments on the new rules. And it makes sense because it avoids future litigation if they try to incorporate the suggestions that are good. And then finally, adjudication. As I mentioned, there are formal tribunals within administrative agencies, formal hearings. And because it's the United States and the Congress, of course, the Constitution is the highest law in all the land, they must give due process. So you must have your say in court. You must be able to challenge these rules, and you must get your right to be heard. So similar due process that is required to the courtroom is required of administrative adjudication as well. So the administrative law judge, unlike in a typical court, rules on both the fact and the law. There are no juries in the administrative law tribunals. The judge acts as both the arbiter of law and the decider of fact. But otherwise, they have very similar powers to courts. They can also have internal appeals that you can appeal within the administrative agency. And if you have gone through all of your appeals within the administrative agency and you're still not getting what you want, and you believe that you've had perhaps your constitutional rights or statutory rights violated, you can ask for judicial review. The agency can give you discretion and say, yes, we believe that the court needs to hear this. But if they refuse to act, you can ask the court once you've exhausted all your administrative remedies. You can't just go to the first administrative tribunal and lose and say, I don't think it's going to be worth my while. I want to go directly to court. You have to exhaust all your administrative appeals first. You have to go up the chain within the agency before you can get judicial review. So that's going to end our rather short module. Now remember, we have other assignments, we have other things to do. But that's it for this module. I look forward to seeing you on the next one.